my lord, so nothing. Yes, my lord, I'm only focusing on, my lord, for your lordship's assistance if on section 21. It's, my lord, relatability to section
One day,
article 324.
on one of the dates, Mr. Naidu said, I am also appearing for the election.
That was not something where the other side.
He said one day, but he never comes after that.
I'll just complete it, my lord, not more than 10 minutes. But just have a look for your lordship's convenience. I've prepared a small compilation. And then, my lord, 2-3 paragraphs, my lord, which your lordships have been told, but I just want to read it with your lordship permission. My lord, if your lordship may kindly take this short note which I have prepared, my lord.
That's right.
Now, my lord, your lordship may kindly permit me to very respectfully urge, my lord, that what your lordships are considering is what is a special revision. Now, is it special revision which is conditioned by the parliamentary made law under Article 327 in the form of 1950 Act or rules, or is it a root and a key to bring back the jurisdiction of the Election Commission directly under 324, of course, subject to the principles of non-arbitrariness and, my lord, the reasonable. That is what I have tried to do it, my lord. Just have a look at page 1. My lord, page 1, my lord, para 1, Mr. Dwivedi has already submitted in detail, my lord. Every, my lord, in my respectful submission, every nation has a policy. It is every sovereign nation has to decide.
2 and 3 have also been explained.
Yes, my lord. And kindly see, my lord, the conditions which are Article 326 conditions, my lord, they are essential conditions for your entitlement for inclusion in the electoral roll. This, my lord, condition, fulfillment of these conditions is a continuous requirement. You cannot say once my name has entered, whether I have lost any eligibility or not, and therefore I must remain there. I am entitled to vote in every election, even when there is a verification exercise to see of continuous fulfillment of those conditions. Then your lordship may kindly come to the next page, para 6. I have only for the convenience, my lord, please see the left side column.
Comparative.
These are the constitutional requirements which are re-emphasized and reiterated, my lord, on the second column by the legislative provisions. Then, my lord, Article 325 is couched in negative, that you will not be ineligible to be included on these conditions. Just permit me to read that table, my lord. No, that is 325 in para 7. No person shall be eligible for ineligible for inclusion in the electoral roll only on grounds of religion, say, race, caste, or sex. So this is, my lord, in the negative, that you would not be ineligible on these grounds. Important is 326, where, my lord, those three conditions which are constitutional essential conditions, my lord, which are required for, my lord, entitlement for being registered in the electoral roll and at any election means at every election. Then your lordship may kindly come to the next page. My lord, on the top, that any would mean every in such context, that is the two lines, the last two lines of para 8. Then, my lord, kindly see 21.1. My lord, 21.1 is preparation. 21.2 is a revision. 21.3 is a special revision. Now, my lord, if you
21.1 is original.
First electoral roll.
Original.
Yes, my lord.
21.2 revision.
Revision. And we say now that
special.
And 21.3, my lord. And then, my lord, if your lordship may just make a note of para 13. I'm not reading it at the same page.
Yes.
And, my lord, in para 13, the terminology of as it thinks fit, my lord, the judgments are only mentioned. I'm not reading it. Please come to page 4. There, my lord, I want to make a submission with regard to para 14 and 15. So, my lord, 324 is the wide and plenary jurisdiction of the Election Commission. By virtue of 327 parliamentary intervention. But, my lord, it's my respectful submission in supplementing what Mr. Dwivedi, our leader, has leader of the team has already mentioned. 21.3 the route, my lord, to bring it back to 324. And, my lord, if I can have the permission, Justice Bakshi, to use the terminology unshackles. See, the conditioning on 324 by virtue of 327 is the 1950 Act and the 51 rules. 21(3) is the parliamentary mandate that there would be situation which we can't see today, where that jurisdiction that is described as plenary and wide under 324 would be required to be vested in the election commission, a constitutional authority once again. But yes, subject to the principles which your lordships have reiterated time and again, reasonableness and non-arbitrariness. Now, my lord, Lal Babu is mentioned in para 18, para 19 of this, one para, my lord, which I wanted to rely and emphasize further. I have quoted it, I am not reading it, my lord. And then with regard to, my lord, the distinction between citizen and non-citizen on the basis of Mr. Dwivedi has also argued that a citizen-centric is para 22, where, my lord, one para of Sonobal, my lord, which was, my lord, I thought that there is emphasis needed. I have quoted it. I'm not reading it. 24 to 27, my lord. I want to make a submission. My lord, the EVM case had already stood decided a number of times. My lord, the apprehensions always used to be expressed about the working of the EVM, and that also became a cause of, my lord, too much of discrediting the Election Commission of India. And there I wish to read, my lord, this few paragraphs of the last judgment of the then Honorable Chief Justice Khanna and, my lord, Justice Datta. I want to come to that, but your lordship may just permit me to say this. My lord, Article 32 in such matters, your lordship have exercised jurisdiction on umpteen times, and it is required to be carried out. My lord, but the test which is laid down in this EVM on such repeated, my lord, discrediting exercises, which, my lord, found observed to be prima facie far from being bona fide. That, my lord, in my respectful submission, has repeated here again. And your lordships have stood satisfied, my lord, in our understanding that when this SIR in Bihar started, similar apprehension, my lord, and primarily only on the basis of the news reports, no other material which could, my lord, test the scrutiny by the court. These three paragraphs, not 24 to 27, I am not reading it, I am emphasizing it. Please come to the next page, my lord.
Annexure.
Annexure A. Now, my lord, on the top, your lordship will see section 21. This is the title of 21, which includes of two components, that is preparation and revision. 21.1, my lord, on the first column, I'm not reading it. Your lordship may just see that is with regard to preparation. 21.2 is in the second column, where your lordship will see the most important terminology shall be revised in the prescribed manner, which your lordship, my lord, even Honorable Chief Justice said that it is used twice over in 21.2, which, my lord, if your lordship come to the third column, now 21.3 in comparison to 21.2, then, my lord, first of all, non-obstante clause, to keep it away from the exercise under 1950 Act and the rules made thereunder, in such manner as it may think fit, and the outcome, my lord, in this, if your lordship come to the next page, last page, my lord, the last page of this, you can skip the other page, kindly come to the last page.
Yeah.
Now, my lord, kindly see, 324 jurisdiction is there, then it is conditioned by 327, subject to the provisions of 1950 Act. For revision 21.2, 21.3 the special revision, which in my respectful submission is once again a parliamentary mandate that we restore the jurisdiction as it is 324 for special revision through 21.3. 321, section 21.3 is the key to go back and enter that room, which, my lord, is on the right side. Now, my lord, only two paragraphs which I just want to flag, my lord, and not read. In the judgment, my lord, in the EVM case, my lord, this is in volume 5R. I requested, my lord, it's taken out. 5R starts at page 108. Kindly come to page, my lord, the top page, my lord, which is running of this volume 146 from para 80 onwards. 80, 81, 82.
Yeah.
And I want to read, my lord, if your lordship permit me, para 81. Mr. Dwivedi had pointed out, my lord, but since I had the privilege to make submission before this honorable court in this case, so I am tempted to, my lord, read it para 81. I place on record that although such a suggestion was subsequent, this was, my lord, that if what eventual relief is being sought by the same petitioner before the Honorable Supreme Court, the answer given was going back to the paper ballot. I place on record, although such a suggestion was subsequently withdrawn by the counsel in course of proceeding that ensued following listing of the writ petition. There also, my lord, the jurisdiction first of all. So many counsel on the other side have argued we are in jurisdiction. Others have said we are not questioning. Then, my lord, my friend Mr. Bhushan said that he gave in written submission, he's questioning, and then said, I'm not questioning. Same thing happened there also. I place on record, although such a suggestion was subsequently withdrawn by the counsel in course of proceeding that ensued following listing of the writ petition for direction to seek clarification of the ECI on certain point, nothing much turns on it. The withdrawal was more of an attempt, please mark it, my lord, to erase the impression the judges forming the bench, were urged to form by the senior counsel by the ECI while arguing that petitioning associations utter lack of bona fide in invoking this court's writ jurisdiction under Article 32 of the Constitution is completely exposed to thereby. I have no hesitation to accept the submission of the counsel for the ECI that reverting to the paper ballot system of the bygone era, as suggested, reveals the re-intention of the petitioning association to discredit the system of voting through EVM and thereby derailing the electoral process that is underway by creating unnecessary doubts in the mind of the electorate. It is of immediate relevance to note that in recent years, a trend has been fast developing of certain vested interest groups endeavoring to undermine the achievements and accomplishments of the nation and through the hard work and dedication of its sincere workforce. There seems to be a concerted effort to discredit, diminish, and weaken the progress of this great nation on every possible frontier. Any such effort or rather attempt has to be nipped at the bud. No constitutional court, far less than this court, would allow such attempt to succeed as long as it has a say in the matter. I have serious doubts as regards the bona fides of the petitioning association when it seeks a reversion to the old order, irrespective of the fact that in the past efforts of the petitioning association bringing about electoral reforms have been borne fruit. The suggestion put forth appeared inexplicable. Question of reverting to the paper ballot system on the facts and circumstances does not and cannot arise. It is only improvements in the EVMs or even a better system that people would look forward to be in the ensuing year. Then, my lord, your lordship, may have just two more paragraphs from 97 at page 151. 97 to 100. There are two other ancillary issues which are to be added, para 97, 98. The first is the very issue of maintainability of writ petitions of the nature presented before us. Should mere suspicion of infringement of a right be considered adequate ground to invoke the jurisdiction? In my opinion, the answer should be no. A writ petition ought not to be entertained if the plea is based on mere suspicion that a right could be infringed. Suspicion that a right could be infringed and a real threat of infringement of a right are distinct and different. And then, my lord, para 100, your lordships have laid down the guidance. So, my lord, in my respectful submission, from the date when these petitions are taken up earlier and with the order which under the guidance of your lordships which are passed, please apply this test, my lord. In our respectful submission, these are not the petitions with any bona fide. These are the petitions more, my lord, to some kind of a design to discredit the constitutional body, and therefore, my lord, it should not deserve any further indulgence by this honorable court, my lord. I'm deeply grateful to your lordship.
I am also a very election in 301.5. Only 2 points I said.
Yes.
I only point on this constitutional consistency and the legislative intent was also there, and the SIR, there is a departure therefrom. Your lordship, I have given also a brief note. Yes. There is a note I did, but I'll not read the entire note, your lordship. I'll just read as 326, your lordship says, which limits the voter registration to citizens or otherwise disqualified. That also was the intent from the beginning at the time of enactment of 1950 Act. In fact, I have annexed your lordship the parliamentary debate. Kindly see that starts at page 12. From page 19, there are 2 pages I'll give your lordship. Page 19, bottom. Dr. Ambedkar, that now I come to registration of voters. Whether 16 will come first or 19 on that, your lordship. The principles adopted for registration of voters for parliamentary constituencies as well as the state legislative assembly constituencies are the same. There is no difference. Consequently, I think that it would be enough if I explain the provisions relating to registration of voters for parliamentary constituencies. The first principle is laid down in clause 15 of the bill, which says that every constituency is to have an electoral roll on the basis of which election will be conducted. The preparation of electoral roll is therefore an obligatory thing and a condition precedent for election. The second principle is that for being registered on an electoral roll, a person should not suffer from any disqualification mentioned in clause 16. So that is citizenship, your lordship. He should not be a person who is not a citizen of India or a person who is that is not relevant, etc. The next principle is that a voter can be registered and that in one and not more than one constituency. Even in that is 19, your lordship. So these are 3, and this is also reiterated, your lordship, at page 24. Again, in another answer to another question. The question, Dr. Ambedkar, this is the bottom, your lordship, last 2 questions at page 24. Sri R.K. Chaudhary, Assam. What about the displaced persons who have come to India now? At that time, your lordship should imagine that even the Citizenship Act was not there. And that time, this is the thinking of the legislature. What about Ambedkar? If you are raising the point, explain it now. We have provided, as you will see in clause 20.6, that anybody who has come to India before 25th July 1949 will be entitled to be registered as a voter in the constituency in which he resided on the date or in any other constituency which he may specify to be his own. What about those who are coming now in 1950? Dr. Ambedkar, what we cannot do, because under our constitution, a voter is required to be a citizen. And our citizenship clause defines citizenship as on the commencement, unless we have a new citizenship law to regulate the position. Those who have come after date, I'm afraid they will have to go without it. So this was the intent from the beginning. And your lordship, SIR, in fact, in the recital 5, 6, 7, and 8, I've said the purpose also, because 21.3 requires to give reasons. And the reasons are well contained, and citizenship is mentioned in at least 3 recitals, 5, 6, and 8. 7 doesn't include that. So therefore, your lordship, that is the purpose and that is the consistency. Your lordship should see that the IAs which were filed only created, your lordships, the process more cumbersome. Otherwise, your lordships, as per the outcome is concerned, there is not a single objection, not a single appeal, etc. So therefore, has voted without any grievance, and therefore this exercise number 32 and those IAs, your lordship, probably add to the difficulties in this exercise of the SIR.
Thank you. Thank you, Mr. Kumar. Yes, Mr. Naidu.
May it please, Millets. Millets, this is the place, Millets, in this country, especially the constitutional courts.
5 minutes?
Millets. Yes, Millets. I'll coincide with 4 o'clock.
Little early, we'll add Mr. Ansariya will also add something.
So,
I will not be able to. Sometimes that is, I will come.
Oh, you will place it, we know very well. You will.
as my lords indicate, Millets, I'll run through. I've just placed before your lordships, Millets, some written submissions. To preface my submissions, Millets, in this country, Millets, the constitutional courts, their doors have never been shut for anybody and everybody. They don't require any particular qualification to knock the doors. And even if they're not articulate, my lords would take care of that one. Somebody else would be given for them at the expense of this institution. But the only thing that's required is that they should have some grievance to ventilate, not to hit the headlines or not to make a mockery of the system. These are the two things which your lordships have frowned upon. The rest has been allowed. Now kindly see, millets, coming to the brass tacks at the basics, millets, the prayer that's been sought in this one. Could my lords have a look at the prayer, millets? At millets 222, volume 3A. I'll read, millets, not to trouble your lordships. In view of the foregoing, the petitioner most respectfully prays that this honorable court may be pleased to call for records and issue a writ, order, or direction in the nature of certiorari, quashing the direction so and so, issued by the respondent so and so, call for the record, etc. It goes on. Millets, it is camouflaged as a writ of certiorari. Is there any quasi-judicial order passed as yet on the date of filing of this writ petition by the Election Commission of India? Well, I will liken this situation to something else. Say, for example, in a departmental proceeding, to initiate the process, the authority concerned may issue a notice. That in itself does not amount to an order in exercise of its quasi-judicial power. It is only the process that's been triggered. Once an order has been passed, then millets, it's amenable for judicial review before your lordships or any constitutional court for that matter. Here, millets, exercising its constitutional power and the statutory power, which are in abundance, which have been exercised so far 13 times to this day, the Election Commission of India has initiated the process of SIR, millets, special intensive revision. And millets, that process, when it was afoot, not the person, not the elector that has knocked the doors of this honorable court, but somebody, the good Samaritan supposed to be, has come here saying that I have an apprehension that they may not do rightly. Can this honorable court ever is inclined rather to interdict a person's constitutional power or a statutory power for that matter in an apprehension that they may not exercise that properly? And millets, in my humble submission, it is nothing but what they seek from your lordships is a writ of prohibition, not certiorari. And my lords could see what are the grounds that could qualify to earn a writ of prohibition from your lordships. Kindly have a look at the grounds. Whether any of the grounds would pass the must. I'll just take your lordships. I will not trouble your lordships to any reference. I'll just say that, millets. What's been said here, the first one only reiterates the scope of 324 article. Nothing else beyond that one's been said. Then ground B says 324, 327, 328. Yes, the ECI has power. They would say that one. Then minutes, kindly come to C. Because the EC's primary responsibility is to be inclusive and ensure universal adult suffrage. The test for disqualification may begin once an equitable and fair process has been applied to create a universal rule. Again, a simile, a sort of an exhortation. Then comes millets D. Because the process of testing for disqualification is not meant to take primary place at the cost of equitable enumeration. I've just been breaking my brains, millets, to understand this phrase of equitable enumeration. It's alliteration, beautiful to sound, but I don't think it makes any sense in that one. Enumeration is legal. Enumeration is statutory. Once it is statutory, even for that matter constitutional, once it is statutory and constitutional, millets, the question of equity just goes into air. It doesn't mean that we are not equitable, but I still say, millets, we are being bound to follow the rule and implement that one. So that somebody's difficulty, we have had elaborate mechanism on place, and to this day, millets, virtually in this case, this honorable court has been cautious enough, vigilant enough, as sentinel on quivi, as my lords have earlier described, to ensure that day to day the whole process has been monitored, elections have been held, and then millets, the result is there, or for to see when it comes to the process and the lapses alleged ones. Not even a single person has had any grievance to this day, except those who have had a separate agenda. Now, millets, these are the grounds they go on in this way, saying that when there has been a natural justice violation, when I have not even began the process in this manner I have just suggested in that one, millets. Could they visualize that there is going to be a natural justice violation? These are the things, millets. The point that they have urged in the next breath is that, millets, that when it comes to the provisions, millets, they say we have not given, when we have issued the notification for SIR, sufficient reasons to justify that one. May I just take your lordships to that, millets, page 354, volume 4A, millets. I will not trouble further, millets, except for a couple of minutes here. My lords could see what's been said in para 5 of this notification is this. Whereas the preparation of electoral roll must ensure that all eligible citizens are included and no such eligible citizen is excluded from the electoral roll. That is the primary purpose of ECI. The very objective is that one, nobody shut out. And the converse could be somebody who has not been eligible may not be in. It goes without saying. Then, millets, whereas the Article 326 of the Constitution stipulates that every person who is a citizen of India and who is not less than 18 years of age on the qualifying date and is not otherwise disqualified under any law shall be enrolled to be registered in the electoral roll. Millets, every computer system will have firewalls so that a particular malware will not enter into that one. As far as this Hon'ble Court is concerned, millets, there are certain firewalls where they have said that the citizen has been robbed of his rights. Your lordships should be really alert. And they would like to impress upon your lordships to that effect, but they failed. This is what I have been submitting. Another firewall they have built for themselves is that, millets, that we are determining, that ECI is determining the citizenship. Millets, determination is different from verification. If I espouse myself to be a lawyer, then I wanted to enroll at the very beginning. Then, millets, I need to produce my certificate. And the Bar Council is not going to determine my qualification. It only verifies my qualification. Here, millets, Election Commission of India, when 18 years somebody crosses, and after 2003, by 2024, they are of eligible voters. And then, millets, they need to establish prima facie, these are the things that I can show to the authorities concerned to qualify myself as a person. Does it amount, in my humble submission, any sort of determination, millets? The answer could be a resounding no. There's no such thing has ever been attempted. My lords have indicated, expand the scope of the documents they can produce. We did that one. And any doubt that could be verified. And anybody shut out, assuming against myself, that without any justification, there is hierarchy of adjudication methods that have been suggested. And I am told, millets, not even one complaint with regard to all these things, except grabbing the headlines or an effort to do that one. Nothing else comes out of this, millets. Now, millets, I've just pleaded in my page 3 of my note, millets, what's the distinction between a verification and determination. And ECI has never indulged in any sort of determination of anybody's citizenship. But once Constitution mandates, then the RP Act mandates, that's the primary hurdle anybody has to cross to earn a vote. If you had been there in 2003, you have had right royal red carpet spread by the ECI itself that you can be a voter, again reaffirmed. But you have come for the first time, you need to have these primary concerns addressed, and then there is a mechanism for you to have that one. And millets, anybody, by lords, have seen that we are not static, we move about. Many people may have moved, may have shifted, may have migrated, or perhaps may have been dead. All these things have to be taken care of. Millets, the proof of pudding, it's in its lying, is the best thing, millets. My lords could see in my note at the end, I've given the statistics with regard to the percentage of voting. In fact, millets, some collateral advantage, as I realize, is that, millets, the collateral advantage of this SIR. Could my lords come to that one, millets?
I'll talk to page 15 onward.
Page 14, millets, my lords could see.
Yes.
My lords could see. Para 55, we have explained, millets. One moment, millets. Yes, millets. An electoral roll with lakhs of absent, shifted and dead voters would naturally have a lesser voting percentage than the voting percentage on a clear electoral roll. The rise of voting percentage of Bihar from 57.29% in 2020 general election to the Legislative Assembly of Bihar at 56.28 percent in 2024 general election to Lok Sabha to 66.91 in general election to the Legislative Assembly of Bihar 2025. My lords could see, my lords, the very next page, the chart that's been given in a tabulated manner at page number 15.
Yes.
It arouses the interest of the common man, because the whole process, they've knocked every door of Bihar. It served the purpose of weeding out the absenteeism, and also it has served the purpose of drafting in the enthusiastic voter. And that's how, Miller, this percent has been there. Had it been a case of what they just had, this doomsday picture presented before your lordships, it could have been disastrous, much less. It's on the canvas, it's on the rise. That's why, millets, it's an empty slogan on their part with regard to the bogey of citizenship. Only thing is that, millets, in the manner accepted by law, somebody has to establish his credentials to enroll himself for the first time, or after the cutting dates of 1987 and other 2003 millets, that also whatever has been required. And that's been examined by your lordships, whether such requirement is beyond the legal purview. It's not in my humble submission. Then, millets, my lords may kindly come to the other aspects that I may just focus on, millets. Kindly come to page 5. Point 4, millets, I've raised. Attempt of petitioners to import the requirement of section 16(1)(b) into 16(1)(a). Could my lords have a cursory glance on section 16, millets, of RP Act 1950? I'll read, millets, without troubling your lordships.
Yes, attempt to.
Electoral row 16, millets. Disqualifications for the registration in an electoral roll. A person shall be disqualified for registration in an electoral roll if he is not a citizen of India or is of unsound mind and stands so declared by a competent court. Millet's declaration as to somebody's state of mind is by a judicial adjudication. And it does not, as I'm given to understand, Millet, they say that it should also be there, that there should have been earlier determination by a competent court that he is not a citizen, etc. You are no person to say that I'm not a citizen. Millet, there are two distinct things. When it comes to a person who has been sane otherwise on the face of it seemingly, may not be. And that's why, Millet, there's a separate procedure for that one. There is a declaration for that purpose. When it comes to citizenship, Millets, it's mandatory. So B cannot be telescoped into A. They are two different things. All that we wanted is a legally acceptable document to show that you can be enrolled as a voter. Nothing more, nothing less. Then, Millets, my lords, may kindly come to page 6, Millets. We have talked about, Millets, section 19. Kindly see that, Millets. Conditions of registration. Subject to the foregoing provisions of this part, every person who is not less than 18 years of age on the qualifying date and shall be entitled, is ordinarily resident in a constituency, shall be entitled to be registered in the electoral roll for that constituency. Another argument, as I'm given to understand, is that, Millets, section 19 does not mandate that he should be a citizen of India, or at least it is not a precondition per se. The very beginning of the sentence, Millets, it's been said subject to the foregoing provisions, and the foregoing provision, section 16, which begins with that one, that's the primary condition. It is only a question of eligibility, and that eligibility may come in different ways as Constitution has mandated. One of the conditions that's mandated is citizenship. The other one is that of 18 years. Then, Millets, the peripherals come in the course of the statutory provisions, and they could be fulfilled. That's why, Millets, we have given the forms, we have knocked the doors, we have taken the trouble of collecting everything, compiling them, and anybody has any grievance, we have given them an opportunity. They've availed themselves of, and they've been happy. I just may come to the next one, Millets. Kindly come to page 7 of my submissions, Millets. Page 7. Let's have a look at para 24 of my note, Millets. In this context, it's also relevant to take note of section 62 of the RPA 1951, which is quoted. Right to vote. No person who is not and except as expressly provided by this act, every person who is for the time being entered in the electoral roll of any constituency shall be entitled to vote in the constituency. Millets, it's a convoluted sentence. Simply put, Millets, everybody whose name is there in the electoral roll is entitled to vote. Then, Millets, the whole process, my lords may kindly appreciate, Millets, in 75 years of the democratic history of this country, Millets, not even a single allegation at any point that elections have been stolen. Even 4 years ago in America, it's been said that when you stole my election, you stole my elections. This is no banana republic because of the sentinel on the qui vive like this court and other constitutional courts, as well as institutions like ECI. And here, my lords may kindly see, once you enter into that one, you determine the fate of the nation as an elector. For that purpose, all that you need to do is just establish that you are qualified in terms of the constitutional mandate and the statutory mandate. Nothing more. Then, Millets. Sorry. Yes, Millets. I may just read, Millets. One more sentence from this one. Section 62, subsection 2. No person shall vote at an election in any constituency if he is subject to any of the disqualifications referred to in section 16 of the Representation of the People Act of 1950. Millets, both have been couched. If you have that threshold mark, you are participating. If you fail, you cannot. Millets, 2003, we have said your name is reflected, no questions asked. And first time you are coming, please provide this prima facie evidence. And if at all any dissatisfaction on your part, you have got the higher echelons to adjudicate your grievance. And every checks and balance have been taken care of, and more so as monitored by your lordships, if I can use that expression. To conclude, Millets, I may submit, Millets, there is no ground to come before this court. It's entirely premature. Anyway, Millets, pending this one, the process has happened. They have also talked about the time frame. Given the technological advances and the manpower at the disposal of ECI, it could, in record time, complete the whole process and then establish that nothing has been amiss. I don't think, Millets, even at this stage, they could point out one lapse as far as Bihar is concerned. Bihar, others are in the way, Millets. It is to be summarily dismissed. It doesn't deserve any recognition, rather judicial acknowledgement or imprimatur from your lordships, Millets. I'm grateful for the opportunity.
Thank you.
Milos, may I please?
Also want to add?
Milos, would your lordships allow me to submit today?
No.
Or maybe I can continue to.
Okay, go ahead, go ahead.
Milos, the difficulty in following seniors of such repute is that there's nothing really left to argue. But one point which remains, which has not been addressed, is that of proportionality. And that is what I will be focusing on, Milos. May I hand over my written submissions? May I please, Milos? Milos, I will not labor on the contours of proportionality. Your lordships are well aware of it. Suffice to say that it is a check, it is a test to check the fairness and reasonableness of any limitation or encroachment on any fundamental or constitutional right. And your lordships typically apply a four-layered structured analysis to test proportionality. That I've captured in paragraphs 1, 2, 3 of my written submissions, Milos. And in paragraph 4, I have captured the arguments of the petitioners. I will not read it. In short, their contention is that the SIR violates all prongs of proportionality. Now, my lords, before I address those contentions, there are three aspects which I would request your lordships to note. One is the ingredients of 326, my lords. In my respectful submission, 326 is in the nature of a self-limiting constitutional provision. It provides for adult suffrage, and it says that anybody who's entitled to be registered on the electoral roll will be done. Now, 326 also contains three preconditions, which is citizenship, 18 years of age, and the elector should not be disqualified on grounds of
unsoundness of mind, non-residence, etc. So, my lords, the submission is that under 326, the entitlement is a qualified right, and without providing proof of qualification, no person can be entered on the rolls. The second submission, my lords, is with respect to scope of 21. It has been dealt with extensively, so I will not labor on this. The only thing that I'll say is, my lords, the phrase "in such manner as it may think fit" should be afforded a wide and a liberal construction. And much like my senior Mr. Maninder Singh, if I may borrow Justice Bagchi's phraseology, what 21(3) does is it unshackles the Election Commission from the rigors of the RER 1960 to devise a mechanism and conduct revision in such manner as it may think fit. The third aspect, my lords, is between a summary, intensive, and a special revision. That is at page 7 of my written submissions.
This has been explained in.
That has been dealt with. The only point that I want to highlight is that under the summary and intensive revision, those are objection-based exercise. The lordships have already noted that. The only way to verify anybody's eligibility under those two forms of revisions is through Form 7. And except for, your lordships have seen Form 7, the burden is on the objector to prove that somebody is ineligible and should be removed from the rules. So barring aspects of perhaps somebody who's absent from the constituency or who is not of 18 years of age or is dead, aspects relating to citizenship, an objector will never be privy to. Because your lordships have seen in Sarvananda Sonowal 2, paragraph 61 and 62 have cited that. This information is in the special knowledge of that person concerned. So that burden will never be able to be met under a special and under a summary and intensive revision under Rule 25. So therefore, if the idea is to check eligibility of all those electors who've not previously undergone an SIR, the only means available is through invoking 21(3). Now, my lords, I'll straight away come to proportionality. In fact, I will also not dwell on the first stage, which is the legitimate state aim. I don't think it's anybody's contention that a pure electoral roll does not serve a legitimate state aim. In fact, it is a core element of free and fair elections, which your lordships have held to be a part of the basic structure. This I have dealt with, my lords, from paragraphs 12 to 14. What your lordships may also note in this regard is that the decision to conduct the SIR was also taken in light of the irregularities that existed on the rules. Along with the time gap, your lordships are aware that for 23 years from the previous SIR, no SIR was conducted. And add to that, my lords, the rapid urbanization, mass migrations reasons which have been recorded in the SIR order. So because of all these reasons, my lords, the decision was taken to conduct an SIR. It serves a legitimate thing. The second stage, my lords, is the rational nexus stage. And at this stage, my lords, the inquiry is whether there is an increased likelihood of achieving the objective. That's the test that your lordships have delineated. It is not necessary at this stage, my lords, that the means adopted should be the only means of realizing the objective. But even if it partially achieves the objective, that will suffice the test. And I rely on, my lords, the electoral bond scheme case. I have cited paragraph 120. I will not read it. It is at page 11. Your lordships will consider it. I've also relied upon Madhyamam broadcasting, paragraph 116. I've put in the citation just below that. So, my lords, just see how the SIR proceeds as far as rational nexus is concerned. House to house enumeration exercise. Pre-filled individual specific, this is very important, individual specific forms are given to each existing elector. All they have to do is they have to affix their signatures, and then those forms are collected and uploaded by the BLO. So the enumeration phase itself serves as the first stage of filtration. Because anybody who's absent, who's dead, who's shifted, his form will not come in, and they will be excluded from the draft rolls. That's the first stage of filtration, first stage of nexus with the object. Subsequently, my lords, all three criteria of all those individuals who have not previously undergone a revision, special revision, will be verified. That's the second stage of filtration. So in short, my lords, it definitely has a nexus with the object of purification. And in fact, even if I were to demonstrate this with a reference to the figures, approximately 60-70 lakh individuals irregular entries have been removed from the pre-existing electoral rolls, which shows that there is a direct bearing with the nexus. And it is an effective form of removing ineligible entries.
How do you apply proportionality principle here?
My lords, I'm grateful for that query. That's my second leg of submissions. Because, okay, then I will straight away come to that, because according to me,
You can
proportionality...
straight come to that point, rest you can leave.
Very well, my lords. Lords, I'm grateful for that. So, just to close the loop, all the four stages of proportionality are satisfied, my lords. I've dealt with those aspects up till paragraph 27 of my written submissions. So, my lords, your lordships have identified, apropos your lordships query, if it applies at all or not. In modern dental, your lordships have identified a working definition of proportionality as the, if I may read it out, I've captured it in paragraph 28 of my written submissions. Proportionality as a set of rules determining the necessary and sufficient conditions or limitation of a constitutionally protected right by a law to be constitutionally permissible. Now, my lords, absent any limitation which is imposed by the ECI, where is the question of applying proportionality? The limitations flow from Article 326, read with Section 16 and 19 of the RP Act 1950. It is not the case that we have come up with a policy and increased the threshold of eligibility, which is not contained in the Constitution itself. All doing is that we are verifying the eligibility parameters. It is not that we have said that apart from the 3 criteria mentioned therein, you have to prove X also and Y also, only then you will be registered on the rules. So absent those limitations, my lords, there's no question of applying proportionality. That's my submission. In fact, at paragraph 31, my lords, I have provided a non-exhaustive set of 5 cases. In all these cases, wherever your lordships have applied proportionality, there was always an added imposition of a limitation. Absent that, there is no application of proportionality. I will not refer to it. Lordships will see it at a later stage.
So the points are almost covered.
Yes, my lords. I'll just take 2 more minutes and I'll close. The third submission on assessment of citizenship, again, it has been dealt with extensively. Your lordships have seen articles 102 and 103. Along those lines, there's one more statutory provision which has not been shown to your lordships, which is Section 14 of the Government of Union Territories Act. Please have paragraph 37, my lords. If I may place that. Section 14 provides for disqualification of membership. And Clause 1 says a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly of the Union Territory. I'll skip subclause A and come to B. I've emboldened that. If he is for the time being disqualified for being chosen as and for being a member of either houses of parliament under provision subclause B and subclause C or subclause D. D is citizenship criteria. And at clause 4, my lords, before giving any decision on such a question, the president shall obtain the opinion of election commission, which shall be binding. So this was one of the provisions which was not shown to your lordships. I've cited that. And at paragraph 38, I've extracted section 146 of the RP Act 1951, which vests judicial powers to conduct such an inquiry. Lastly, my lords, at paragraph 39, I've cited 3 cases, 2 of which are constitution benches, which say that the opinion of the ECI is binding. In fact, your lordships may just mark NG Ranga's case, where it was held that even where a complaint is whimsical or frivolous, the president is obliged, or the governor, whatever the case may be, is obliged to send it across to the ECI, and it is ECI's prerogative to take a decision whether to initiate an inquiry or not. Plus, these are my submissions. I'll close by saying that merely because in the name of an organization the term democratic exists, does not mean that they are working towards strengthening the democratic fabric of this country. I'm very grateful for the patient hearing this.
Thank you. Mr. Acharya, 10 minutes tomorrow. No, not more than this.
Repeat anything.
No, 10 minutes, that's all. No, nothing more.
Able to do that. Then I'll give my written submissions to lots of it.
Rest you can give in writing.
I have prepared, not but then 10 minutes. I will not be able
10 minutes only tomorrow.
then consider.
I just need 1 minute time to say only something new. We are appearing
No, like 1 minute.
from Bihar.
1 minute you take right now.
Let's see. Very good. We wanted to point out 2 things. As far as state of Bihar, we have filed a fresh writ petition praying for a mandamus to be issued to the EC to carry out an SIR revision as far as for both MLA and MLC elections. We pointed out an order of the High Court of Bihar itself has taken cognizance of the fact that there are large amounts to Bihar. Please create detention centers, and there are enough number of immigrants in the state of Bihar notified, assessed as such. Home detention facilities have to be created. Therefore, the factum of large-scale immigration in Bihar is no longer in doubt. There are 8 districts which have porous border with Nepal and several others. Second, Malas, the Election Commission has conducted electoral roll revision for the MLC elections. Now, this, Malas, has not been informed to the Honorable Court that 15 to 26 deal with elections, but 27 onwards deal with the election to MLCs. The Lordship knows there are 6 states in India which have legislative councils, and elections for these legislative councils are held every 6 years. Now, Election Commission has been conducting the revision of rolls for teachers and students, graduate constituencies every 6 years before the election. In fact, currently as we speak, a revision is going on for elections in some seats scheduled in 26. But no revision was conducted for a period of 22 years as far as assembly elections are concerned. Therefore, we are praying, well, that your lordship may consider issuing a mandamus to the EC in terms of 21(2)(a). The worst uses shall be revised. The Election Commission ought to comply with that mandate to consider revising the roll before every election, Malot, that takes place. And Malot,
Done.
that's it.
Your Lordship, notice
I
because
will try to.
Assam SR,
We
your
will
Lordship
give extra time tomorrow so that we can bind up. Thank you. Thank you very much.
Welcome.